Hey, my pro-life friends. I'm Mary Taylor. I am the president of Pro-Life Utah, and I'm here today because I've had a lot of questions around what happened last week at the Utah Supreme Court regarding our Utah abortion law. So I'd like to go through that just a little bit, go through the history and talk about what we expect going forward. Now, last week, the Utah Supreme Court handed down a ruling. This was not a ruling on the underlying case. What it was a ruling on the preliminary injunction that the Third District Court had placed on our law back in 2022. So let's go through the history just a little bit. In 2020, we passed Senator Dan McKay and Representative Glisenby, and Pro-Life Utah worked closely with them, along with the Utah Eagle Forum and others. But we passed a trigger abortion law that basically, it's a great law, basically life at conception law. So it would ban all abortions in the state of Utah with the exceptions of rape, incest, life of the mother, and fatal fetal abnormalities. Now, at the time, Roe v. Wade blocked that law from going into place. So we placed what they call a trigger on the law that is just a clause that says what triggers this bill to become a law is Roe v. Wade being overturned. Now, I will tell you at the time that we were passing this law, I had no hope that that was going to happen anytime soon. I prayed that, someday in the future it might do some good, but we'd lived with Roe v. Wade for 50 years, so I just really didn't have high hopes that that was going to change anytime soon. But boy, was I wrong. And 2 years later, in 2022, June 24th, 2022, Roe v. Wade was in fact overturned by the federal Supreme Court in the Dobbs versus Jackson Women's Health case. Now, that ruling was announced on a Friday morning, and our AG's office went through the ruling, went through our law, and determined that everything was a go, and that became the law of the land here in Utah by Friday afternoon. We were abortion-free. There was no legal abortion in Utah for the weekend, and that's as long as it lasted. By Monday morning, Judge Andrew Stone had placed an injunction on our abortion law. Planned Parenthood sued the state based on grounds that the trigger law violated multiple Utah state constitutional provisions, and they requested that a preliminary injunction block the bill from going into effect while the lawsuit went through the court system. Now, the preliminary injunction was based on or granted upon a serious issue to be resolved. You see, an injunction can be granted on one or more of two different grounds here in Utah. One was that Planned Parenthood was likely to prevail on the case, and two was that there were serious issues raised. Well, Judge Stone actually passed or granted the injunction based on the serious issue clause. Now, since that time, our legislature has passed a law that removes the serious issue reason from the injunction process. Representative Brady Brammer passed that law, and boy, if we would have had that law in place when our abortion law went into effect, we would be in a very, very different place today. But unfortunately, we did not, and we're dealing with the older laws surrounding injunctions. During the hearing for the preliminary injunction, Judge Stone talked about the serious issue or harm that could come to Planned Parenthood. Not once did he mention the serious issue or the harm that would come to the unborn child. The Utah Attorney General's office appealed that preliminary injunction, and the Supreme Court, the Utah Supreme Court, heard that case on August 8th, 2023. The AG's office argued that the injunction should be lifted because, one, Planned Parenthood had no standing in the case. You see, typically a plaintiff has to be a person that could be harmed by the law. And Planned Parenthood brought this case on behalf of some theoretical woman somewhere in the future that could somehow be harmed. And two, there is no stated or implied right to abortion in the Utah State Constitution. And I would just implore you to read the Utah State Constitution. You will not find the word abortion in any way, shape, or form, and you will find nothing that was ever intended to imply a right to abortion. So we waited a year for that injunction hearing and another year for that ruling, 2 years of waiting, and 6,000 babies dead. 6,000 unborn babies died, over 6,000, in horrific and brutal abortion procedures. But on August 1st, the Supreme Court finally handed down a ruling. It was a 4-1 decision that the Third District Court was within its power to grant that injunction based on the serious issue basis. Only Chief Justice Durant voted to revoke the injunction based on standing. Now, Judge Durant said that that Planned Parenthood could not sue. They call it third-party standing, that this law did not allow for third-party standing to sue over this law. But unfortunately, the other 4 justices voted to uphold the injunction based on, quote, serious issues of constitutionality, end quote. Now, most disturbing in this ruling is the fact that the justices appear to be considering that that there is somehow a right to abortion in the Utah state constitution. And even more disturbing than that is the fact that these justices appeared not to consider the unborn baby at all in their decision. They definitely considered Planned Parenthood's bottom line, which is dependent on the death of unborn babies, but violating these babies' most basic human right, the right to life, that wasn't mentioned at all. So going forward, the case will now go back to the Third District Court. Judge Andrew Stone has retired, and Judge Stomont will now preside over the case. So it's likely that both sides will ask for a summary judgment, and the Third District Court will then have to rule on whether or not there is a right to abortion in the Utah state constitution. Now, there's been several amicus briefs filed with the court on different issues, including one filed by Pro-Life Utah. And Pro-Life Utah's amicus brief is very interesting. It goes back through the history of Utah with newspaper articles and different historical things to show that our ancestors never, ever intended to write a right to abortion into our Constitution. The Utah State Constitution does not address abortion. It does not imply that right in any way, and our history clearly shows that. Abortion was frowned upon by society at that time, as it is for some of us today. Planned Parenthood, on the other hand, argues that the equity language in our Constitution somehow gives a right to abortion. Now, certainly the Utah Constitution and every single amendment that has ever been passed never, ever intended that. So where do we go from here? Well, whatever happens in the Third District Court, no doubt the case will then be appealed to the Utah Supreme Court, and we'll be back at the Utah Supreme Court again. Look for that case to go back to the Supreme Court in approximately 1 year. And in the meantime, more and more and more babies will die through abortion. What will the Supreme Court find then? We don't know, but I'm very concerned about it. Most of us had a good feeling about this case in the beginning, but I don't know. When you read the opinion of the injunction ruling, there are some very, very disturbing things in there. So we'll be watching. We'll be keeping you up to date as things develop. And please pray. Please pray for these justices. Pray for a short resolution so that babies can be protected here in the state of Utah. We sure appreciate your support. Thanks.